5 seconds to go. Start. An investigating officer, being a public servant, is expected to conduct the investigation fairly. While doing so, he is expected to look for materials available for coming to a correct conclusion. He is concerned with the offence as against an offender. It is the offence that he investigates. Whenever a homicide happens, an investigating officer is expected to cover all the aspects and, in the process, shall always keep in mind as to whether the offence would come under section 299 IPC sense section 300 IPC. In other words, it is his primary duty to satisfy that a case would fall under culpable homicide not amounting to murder and then a murder. When there are adequate materials available, he shall not be overzealous in preparing a case for an offence punishable under section 302 IPC. We believe that a pliable change is required in the mind of the investigating officer. After all, such an officer is an officer of the court also, and his duty is to find out the truth and help the court in coming to the correct conclusion. He does not know sides either of the victim or the accused, but shall only be guided by law and be an epitome of fairness in his investigation. There is a subtle difference between a defective investigation and one brought forth by a calculated and deliberate action or inaction. A defective investigation per se would not enure to the benefit of the accused unless it goes into the root of the very case of the prosecution, being fundamental in nature. While dealing with a defective investigation, a court of law is expected to sift the evidence available and find out the truth on the principle that every case involves a journey towards truth. There shall not be any pedantic approach either by the prosecution or by the court, as a case involves an element of law rather than morality. Our aforesaid observation is to point out the approach of the investigating officers and at times courts. There is a clear distinction in the code on knowledge and intention. We do not wish to reiterate the settled position of law, but meant only to state a sleeping mind. An offence would involve an element of mental rebellion when the mind of a person creates an action not supported by the ethos and values of a social structure in the form of law. This deviant behavior is the harbinger of an offence ultimately. A feeling of pain, sorrow, or tragedy is mental. It is what we think and not what we suffer that constitutes an action in us. Such an action might at times create a social deviance. It is this part which is expected to be seen both by the investigating officer and the court while dealing with a criminal case. We would only reiterate the aforesaid principle qua a fair investigation through the following judgment of Kumar versus State 2018 7 SCC 536. The action of investigating authority in pursuing the case in the manner in which they have done must be rebuked. The High Court on this aspect correctly notices that the police authorities have botched up the arrest for reasons best known to them. Although we are aware of the ratio laid down in Prabhu versus King Emperor, wherein the court had ruled that irregularity and illegality of arrest would not affect the culpability of the offence if the same is proved by cogent evidence, yet in this case at hand, such irregularity should be shown deference as the investigating authorities are responsible for suppression of facts. The criminal justice must be above reproach. It is irrelevant whether this falsity lie in the statement of witnesses or the guilt of the accused. The investigative authority has a responsibility to investigate in a fair manner and elicit truth. At the cost of repetition, I must remind the authorities concerned to take up the investigation in a neutral manner without having regard to the ultimate result. In this case at hand, we cannot close our eyes to what has happened, regardless of guilt or the asserted persuasiveness of the evidence. The aspect wherein the police has actively connived to suppress the facts cannot be ignored or overlooked. A fair investigation would become a colorable one when there involves a suppression. Suppressing the motive, injuries, and other existing factors which will have the effect of modifying or altering the charge would amount to a perfunctory investigation and therefore become a false narrative. If the courts find that the foundation of the prosecution case is false and would not conform to the doctrine of fairness as against a conscious suppression, then the very case of the prosecution falls to the ground unless they are unimpeachable evidence to come to a conclusion for avoiding a punishment on a different charge. Stop.